My mother had me removed as the trustee of my own children's education fund while I was lying in a hospital bed. And I want to tell you that I did not find out in the hospital and did not find out from a phone call and found out on a cold Thursday morning when I came home after 10 days of surgical recovery and found an official certified copy of an emergency trustee substitution order sitting on my kitchen counter. And I stood in my hallway in my coat with my hospital bag still on my shoulder, and I looked at the document and I read it twice, and I put my bag down and I took off my coat and I sat at the dining table and I read it a third time. I need to tell you who I am before I tell you what I did, because the two things are connected in a way that matters. And I am the head of the Family Law Compliance Unit at the Central Judicial Directorate. And I have held that position for 7 years. And before that, I spent 5 years as a senior compliance analyst in the same unit. And the unit's function is the oversight and integrity auditing of family court trust structures and guardian appointments and trustee substitution orders. And I review these documents every day, and I know what a legitimate one looks like, and I know what a fraudulent one looks like, and I know the difference between them at the level of document architecture and not just at the level of content. The document on my kitchen table was not legitimate. I want to tell you about the 10 days I had been away because I think the context of those days matters, and the context is this, which is that I had undergone a surgical procedure that had been scheduled for 6 weeks and that had produced a complication on the second day that had required a second procedure, and the second procedure had required a recovery period that my surgical team had managed carefully and had discharged me from on the Thursday morning. And the 10 days had been the kind of 10 days that reduce a person to their most fundamental version of themselves, which is horizontal and dependent and focused entirely on the next meal and the next medication and the next conversation with the consultant. And I had not been focused on my children's education fund, and I had not been focused on the central judicial database, and I had been focused on recovering, and my mother had known this because she had visited me on the third day and had sat beside the bed and had held my hand and had said that she was worried about me and that I needed to rest and that everything at home was being handled. I had believed her. The substitution order had been filed on the 5th day of my hospital stay. I read the filing date on the document 3 times because I wanted to be precise about the timeline. And the timeline was this, which was that my mother had visited me on the 3rd day and had held my hand and had told me to rest and had filed an emergency trustee substitution application with the family court on the 5th day, citing my permanent medical incapacity and my mental unfitness to manage financial assets. And the application had been granted on the 7th day, and the substitution had been processed on the 8th day, and I had been discharged on the 10th day, and the document had been delivered to my kitchen counter by a court courier, while I was still in the hospital, and my mother had a key to my house because I had given it to her 6 years ago when my youngest was born. And she had used that key to collect the certified copy from my doormat and place it on my kitchen counter, where she knew I would find it. When I came home, I sat at the dining table for a long time. I did not call my mother. I did not call my sister Amara, whose name appeared in the substitution order as the replacement trustee. And I did not call my husband, and I did not call anyone. And I sat at the table in the specific stillness of a person who has received information that is both personally devastating and professionally recognizable. And the professional recognition was the part that organized the stillness into something useful. I opened my secure state-issued laptop. The central judicial infrastructure has a case filing search function that is accessible to compliance unit heads through a secure, authenticated portal. And I logged in through the two-factor system. And I entered the case filing number from the substitution order, and the case file opened, and I read the full application from the beginning, and I read my mother's witness statement, which described me as permanently incapacitated and mentally unfit, and I read the supporting documentation list, and I opened the supporting documentation, and the first attachment was a medical letter. The letter was on the headed paper of a private clinic. I knew the clinic. My mother had been a patient of that clinic for 11 years, and I had driven her to appointments there on 4 occasions over the years. And the letter stated that I had been assessed by the clinic's psychiatric team and found to be suffering from a condition that rendered me permanently unfit to manage financial assets or make decisions on behalf of dependents. And the letter bore a consultant's signature and a clinic stamp, and a date that was 1 day before the substitution application was filed. I had never been assessed by that clinic. I had never been assessed by any psychiatric team. I looked at the signature on the letter. I looked at the clinic's name. I thought about the central judicial database that my compliance unit monitors every single day. I opened a new case intake form. I arrived at my compliance workstation on Friday morning at 8:35, and I want to tell you about the workstation because I think the physical environment of the work matters to the understanding of what I did in it. And the workstation is a secured desk on the 4th floor of the Central Judicial Directorate, and it has 2 monitors and a secure terminal that requires biometric authentication and a daily rotating access code, and the terminal connects to the central judicial infrastructure through an encrypted pipeline that is audited quarterly by the Directorate's own security division. And I have worked at this desk for 7 years. And I know its systems the way I know my own handwriting, which is precisely, and without needing to think about the mechanics of the knowing. I authenticated at 8:37, I opened the compliance unit's case intake system, and I retrieved the draft intake form. I had begun at my dining table on Thursday evening, and I completed the remaining fields, which were the evidentiary classification field, and the fraud category field, and the referring authority field, and the priority designation field. And I want to tell you about the priority designation, because it matters. And the priority designation I selected was Category 1 Urgent, which is the designation used when a fraudulent document has been introduced into an active court file, and the fraudulent document affects the welfare of a protected class of beneficiary. And the education fund's beneficiaries were my 3 children. And children are a protected class under the Directorate's compliance framework, and the Category 1 Urgent designation does something specific when it is applied, which is that it removes the case from the jurisdiction of the local court clerks who process the original substitution order and locks the entire file under a federal fraud marker that can only be accessed by the compliance unit and the Senior Judicial Oversight Committee and no one else. I submitted the intake form at 8:51. The automated document forensics queue received the submission at 8:52. And I watched the status indicator move from submitted to received, and I noted the timestamp in my notebook, and I opened my regular queue, and I processed the items in my regular queue for the rest of the morning with the same quality of attention I brought to everything. Because the other files in my queue contained other families and other children, and they deserved the same quality of attention that my own case was receiving from the automated system. And I did not give my own case more of my attention than it required. At this stage, which was none because the system was doing what the system was built to do. On Sunday evening, I drove to my mother's house for dinner. I want to tell you why I went, because I think the reason matters. And the reason was not that I wanted to see my mother, and was not that I had forgiven anything. and was that I needed to understand the full scope of what Amara intended to do with the trustee position. And I could not understand the full scope without being in the room where Amara was willing to describe it. And Amara was always willing to describe her plans in rooms where she believed she was the most powerful person present. And on Sunday evening, she believed that Amara was already talking about the fund. When I arrived, she was sitting at my mother's kitchen table with a document that she had printed, and the document was a prospectus for an offshore investment structure. And she was explaining to my mother that she had spoken to a financial advisor, and that moving the education fund into the offshore structure would protect it from taxation and increase its yield. And my mother was listening with the specific quality of attention she gave to Amara's plans, which was full and admiring, and I sat down at the table, and I listened, and I looked at the prospectus, and I noted the name of the offshore structure and the jurisdiction it was registered in. And I noted both things in the notebook I kept in my bag, and I said nothing. My mother looked at me at some point during the dinner. She said that I was looking better than she had expected, and that the hospital had clearly done me good, and that rest was what I had needed, and that she hoped I understood that the decisions that had been made while I was resting had been made out of love and out of concern for the children's security, and that she hoped I was not going to make this difficult. I said that I was feeling much better. Thank you. I said it in the register. I use for accurate statements, which is level and without additional content. And my mother looked at Amara, and Amara looked at the prospectus, and I picked up my fork and I continued eating. And the dinner continued, and I watched my mother and my sister move through the evening with the specific ease of people who believe a situation has been resolved in their favor. And I sat at the table and I ate the food, and I said what the occasion required, which was not very much. I drove home at 9:40. I sat in the car outside my house for a moment. I thought about an offshore investment structure registered in a jurisdiction that the directorate's compliance framework classifies as a high-risk asset movement destination. And I thought about a category. One urgent intake form submitted at 8:51 on Friday morning. And I thought about what a federal fraud marker does to a court file when a trustee attempts to move assets under its protection into a high-risk offshore jurisdiction. And the answer is that the marker triggers an automatic asset freeze that locks the fund completely until the compliance review has concluded. I went inside. I made tea. I went to bed on Monday morning. I arrived at my workstation at 8:35, and I authenticated. And I opened the workflow dashboard, and the dashboard showed 2 new entries on the Category 1 urgent case, and the first entry was a document forensics preliminary flag generated at 14:22 on Friday afternoon, which meant that the forensic team had begun examining the medical letter within 6 hours of my intake submission, and the second entry was an asset protection measure confirmed generated at 16:07 on Friday afternoon, which meant that the education fund had been frozen at 4 minutes past 4 on Friday, and Amara had spent Sunday evening showing my mother an offshore investment prospectus for a fund that had been completely inaccessible since Friday afternoon. I noted both timestamps in my notebook. I noted the gap between Amara's Sunday evening prospectus and the Friday afternoon freeze. I opened my regular queue. There were 8 items waiting. I processed the first one, and I moved to the second. And the morning continued, and the fund was frozen, and the forensic team was working, and the system was doing what the system was built to do. And my mother and my sister were going to find out what the system had been doing on their own timeline, and not mine. And I was at my desk, and I was doing my work, and the work was enough, The asset protection measure that the compliance system applied on Friday afternoon at 16:07 is not a visible event from the outside. And I want to explain what I mean by that, because I think the explanation matters. And what I mean is that the freeze does not generate a letter, and does not generate a phone call, and does not announce itself to the trustee or to the fund's financial institution in advance, and simply exists as a data instruction transmitted from the directorate's secure pipeline to the financial institution's compliance gateway. And the compliance gateway receives the instruction and applies it silently. And the application means that any transaction request submitted against the fund will be rejected at the gateway level before it reaches a human processor. And the rejection will appear to the person submitting the request as a standard processing failure. And the person submitting the request will not be told why, and will not be given a reference number, and will be told only that the transaction cannot be processed at this time, and to contact their financial institution for further information. The financial institution cannot provide further information. The financial institution has received a directorate compliance instruction, and the instruction requires the institution to maintain confidentiality about the existence of the freeze until the compliance review has concluded, and the institution will comply with the instruction, because the institution is required to comply with it. Under the judicial compliance framework's statutory information, governance provisions, and noncompliance carries consequences that the institution's own legal team will have explained to them in detail when they sign the data sharing agreement with the directorate. 12 years ago, I watched the interaction log on Wednesday morning. The interaction log showed an entry generated at 11:23 on Wednesday, which was a trustee credential rejection event. And the rejection event occurs when a newly assigned trustee attempts to authenticate against a frozen fund using the credential set that the substitution order entitled them to use, and the authentication is rejected by the gateway, and the rejection is logged and transmitted to the compliance unit's monitoring feed. And I read the log entry, and I noted the timestamp, and I noted the attempted transaction amount, which appeared in the rejection metadata as £40,000, and I noted the destination field, which was partially visible in the metadata. And the partial destination contained a jurisdiction code that corresponded to the offshore structure. Amara had shown my mother on Sunday evening. I noted all of this in my notebook. I closed the interaction log. I went back to my queue and I processed the items in my queue. And at 12:30, I went to the small kitchen on the 4th floor and I made lunch and I ate at my desk and I processed the afternoon queue, and at 5:30, I closed my workstation and I went home and I made tea. And I was standing at the kitchen counter waiting for the kettle when my phone showed my mother's name. I let it ring 4 times. I answered. My mother's voice was not the voice she had used on Sunday evening, which had been the voice of a woman who believed she was managing a situation successfully, and was the voice of a woman who has attempted to do something, and has found that the doing has been prevented and does not yet understand by what. And the not understanding was making the voice louder than it would otherwise have been. And I could hear Amara in the background. And Amara's voice had a quality that I recognized, which was the quality of a person whose plan has encountered an obstacle that the plan had not accounted for, and who is responding to the obstacle with volume rather than analysis. My mother said that the bank had blocked Amara's transfer. She said that Amara had tried twice, and that both times the bank had said the transaction could not be processed, and that they had called the bank, and the bank had told them nothing useful, and that she needed to know what was happening and whether I had done something, because she knew I worked in the court system and she knew I had access to things. And she said the word access with the specific emphasis of a person who is beginning to understand that access is a more significant word than she had previously treated it as. I picked up my glass of water. I took a sip. I said that the judicial compliance framework does not experience random processing failures, and that a trustee credential rejection of the kind Amara had encountered is generated by a specific set of system conditions, and that I had no access to locked investigation files and had not had access to any file connected to the family court's case management system since the category 1 urgent intake submission removed the case from standard access levels on Friday morning, and that everything that had happened since Friday morning had been executed by the automated compliance system and the document forensics unit operating under their own protocols, and that I had no information about the specific transaction failure Amara had experienced and could not discuss active compliance reviews under any circumstances. My mother said that this was not an answer. I said that it was the accurate answer, and that accurate answers were the only kind I had available. Amara said something in the background that I did not respond to. My mother said that they were going to call a lawyer. I said that seemed reasonable, and that I hoped they found one who understood judicial compliance framework provisions thoroughly. And I said goodnight, and I ended the call. I turned the phone face down on the kitchen counter. I picked up my tea. I thought about a lawyer attempting to file an emergency motion to lift a category 1 urgent federal fraud marker on a family court trust file. And I thought about what that motion would encounter, which was the compliance unit's automated response protocol, which requires any legal challenge to a Category 1 marker to be submitted through the directorate's formal case challenge system and reviewed by the Senior Judicial Oversight Committee, and the review timeline for Category 1. Challenges is 45 working days, and the 45 days begin from the date of submission and not from the date the lawyer makes the phone call. I opened my laptop. I opened my morning audit queue, which I had not finished before I left the office. There were 3 items remaining. I processed all 3 before I went to bed. The fund was frozen. The forensic team was working. The lawyers my mother was about to call were going to spend 45 working days learning what I had known since Friday morning, which was that the system my mother had tried to use as a weapon was the system I ran, and the system I ran did not make exceptions and did not accept phone calls and did not care how much the lawyer charged per hour and simply continued doing what it was built to do, which was protect the people. It was designed to protect. My children's fund had not moved. It was not going to move, not until I said so. I arrived at the Central Judicial Directorate headquarters at 7:45 on Monday morning, and I want to tell you about the building because I think the architecture of the place communicates something important about what happened inside it. And the building has a public reception suite on the ground floor that is separated from the operational floors by a biometric security barrier. And the public reception suite has the specific quality of a space that has been designed to be functional rather than comfortable. And the furniture is institutional, and the lighting is consistent, and the security officers at the desk have been trained to maintain a quality of composure that does not change regardless of what the person on the other side of the desk is doing. And I had observed that composure many times from the operational side of the barrier. And I had always found it to be one of the most effective institutional tools available because composure in the face of volume is a form of power that volume cannot overcome. I authenticated on the 4th floor at 7:47. I opened the workflow dashboard, and the dashboard showed 3 new entries on the Category 1 urgent case since Friday evening. And the first entry was a document forensics confirmation generated at 9:18 on Friday evening, which meant that the forensic team had completed their preliminary analysis of the medical letter within hours of receiving it. And the confirmation carried a fraud probability rating. And the rating was the highest rating the forensic unit assigned. And the second entry was a trustee profile restriction, generated automatically when the forensic confirmation reached the threshold required to trigger the restriction protocol. And the restriction had been applied to Amara's trustee credential set at 9:21 on Friday evening, 3 minutes after the forensic confirmation. And the third entry was a blacklist flag generated at 9:22, which meant that Amara's profile had been entered into the judicial infrastructure's restricted practitioner database. And the restricted practitioner database is shared with every financial institution that holds an agreement with the directorate. And the sharing had occurred automatically and immediately. I noted all 3 timestamps in my notebook. I went back to my regular queue at 9:34. The interaction log updated, and the update showed a credential authentication attempt made at the bank counter inside the court block at 9:29, and the authentication had used Amara's emergency trustee clearance token, and the authentication had been rejected, and the rejection code was blacklist active, which is the code the system generates when a profile appears on the restricted practitioner database, and the rejection had been logged, and the log had been transmitted to the document forensics unit as a supporting evidence entry. And I read the log entry, and I noted the timestamp, and I noted that Amara had attempted to use her trustee clearance token at 9:29 on a Monday morning, which meant she had come to the courthouse before she understood what the courthouse now knew about her. And I noted that, and I went back to my queue. She called Mom called the clinic. And I know this because the interaction log showed 2 calls received by the directorate's main reception switchboard between 9:40 and 9:55. And the first call was from a number I recognized, and the caller had asked to speak to whoever was responsible for a trust compliance matter and had been told that active compliance matters are handled through the formal case communication process. And the second call was from the clinic whose headed paper had been used for the fraudulent medical letter. And the caller from the clinic had asked whether the directorate had received a medical letter submitted in connection with a family court application. And the reception officer had followed the external contact protocol and had taken a name and a number and had provided the formal case communication process details and had ended the call at 10:08. The reception camera feed, which I can access from my workstation as a facility monitoring function, showed 4 individuals entering the public reception suite, and I recognized 2 of them, and the other 2 were carrying document cases and wearing the specific quality of clothing that private lawyers wear when they intend to make formal representations. And my mother was speaking before she reached the security desk, and Amara was beside her, and Amara's face had the quality of a person who has tested the system twice and been rejected twice, and has now decided that presence will accomplish what credentials could not. The security officer maintained the quality of composure. I had described the lawyers placed documents on the desk. My mother said something that the camera feed did not carry audio for, but that I could read from the quality of her posture, which was the posture of a woman making a demand she believes is reasonable. And the security officer picked up the internal telephone. The doctor's reveal came at 10:17. Dr. Evelyn Vance is the Chief Medical and Corporate Validation Officer of the Directorate's Compliance Division, and she has held that position for 14 years. And she appeared through the door beside the security barrier at 10:17, and she crossed the reception suite, and she stopped at a professional distance from my mother and Amara and the 2 lawyers. and she said that she was the senior officer responsible for the category. One urgent matter that had brought them to the building, and that she wanted to provide them with information before the mandatory data verification meeting that had been scheduled for 11. She said that the falsified medical incapacity letter submitted in support of the emergency trustee substitution application had been examined by the directorate's document forensics unit, and that the examination had produced a fraud determination, and that the fraud determination had been formally logged with the court's fraud division at 9:22 that morning. She said it in the register she used for everything, which was level and without performance. The lawyer on the left said something. Dr. Evelyn Vance said that formal representations should go through the case communication process, and that the mandatory data verification meeting would begin at 11 in the lower ground floor suite, and that attendance was required under the directorate's statutory compliance powers. She turned and walked back through the barrier door. I watched the reception camera feed from my workstation on the 4th floor. My mother sat down on one of the institutional chairs. Amara stood beside her with the 2 lawyers, and the 4 of them had the quality of people who had arrived with a plan and had discovered that the building they were standing in had been designed specifically for situations where plans of that kind encounter the thing they were not designed to encounter. The workflow dashboard updated at 10:32. Mandatory verification meeting. Confirmed lower ground. Floor 1100 hours. 4 attendees logged. I noted the timestamp. I opened my queue. There were 6 items waiting. I processed the first one, and I moved to the second, and the morning continued, and the lower ground floor suite was 2 floors below me. And the meeting would begin in 28 minutes. And I would not be in the meeting, and the meeting would proceed according to its own protocol and its own rules. And the protocol did not require my presence, and did not require my voice, and did not require anything from me at all, because I had submitted an intake form on a Friday morning, and the system had done everything else, and was still doing it, and would continue doing it until it was finished, and finishing was what it was built for. I arrived at the 8th floor at 7:30 on Tuesday morning, which was 90 minutes before my assistant had scheduled the family meeting, and I want to tell you about the executive suite on the 8th floor because I think the space matters to what happened inside it. And the suite occupies the corner of the building that faces east and south, and has floor-to-ceiling glass on both of those sides. And the glass is the kind that is used in institutional buildings where the architecture is intended to communicate that the people inside it operate in full transparency. And the transparency is not a metaphor and is a structural fact. And the light that comes through it in the morning is not warm and is the flat, precise light of a space that does not soften what it contains. And the desk is large and positioned so that the chair behind it faces the door, and the person behind the desk has the light at their back, and the person across from the desk has the light in their face. And I had sat behind that desk for 7 years, and I had never needed the light arrangement to do any particular work. And on Tuesday morning I did not need it either. I read the compliance folder for the 3rd time between 7:30 and 8:45. The folder contained the document forensics unit's full report on the medical letter, and the report was 41 pages. And I had read it on Monday evening, and again on Tuesday morning, and the report's conclusion was the same each time, which was that the medical letter submitted in support of the emergency trustee substitution application had been produced on headed paper that matched the clinic's registered template, but that the consultant's signature had been generated using a digital reproduction tool and not a wet ink instrument, and that the clinic's own records contained no entry for an assessment of the protagonist on the date stated in the letter, and that the clinic's chief medical officer had provided a signed statement confirming that no assessment had taken place and that the letter was not authorized by the clinic and had not been produced by any member of the clinic's staff. I closed the folder. I placed it in the center of the desk. I turned the chair to face the east glass wall, and I looked at the city, and I waited. My assistant knocked at 9:13. She said that the party had arrived, and I said to bring them up in 3 minutes, and I heard her steps in the corridor, and then the lift, and then the specific sound of a corridor containing people who have been directed somewhere they did not choose to go. And at 9:17, the door opened. My mother came through. First, my mother's quality on Tuesday morning was the quality of a woman who had decided before entering the building that she was going to manage whatever she found inside it, and the managing was visible in the way she carried herself, which was with the forward energy of a person who believes their presence is sufficient to alter the situation they are walking into. And she looked at the glass, and she looked at the desk, and she looked at the chair, which was facing away from her. And she moved further into the room. Amara came in behind her. Amara's quality was different from my mother's quality and where my mother was forward. Amara was careful, and I had always known the difference between those two qualities in the people I observed professionally and careful in a person. Entering a compliance director's office means a person who has begun to understand that the office knows something they do not yet fully know and is trying to read the room before the room reads them. I turned the chair. I want to tell you about the silence that followed, and I want to tell you about it with the precision it deserves, which is that it was not the silence of a pause and was the silence of a complete reorganization of understanding happening in two people at the same moment. And the reorganization had stages, and the first stage was recognition, and the second stage was recalibration, and the third stage was the specific stillness that arrives when recalibration produces an outcome that cannot be immediately processed. And I watched all 3 stages move across my mother's face and across Amara's face. And I sat in the chair and I said nothing, and I let the stages complete themselves. My mother's response when the stages completed was to speak. She said that this was not fair. She said it twice, and then she said that this was a private family matter, and that a family matter did not belong in a court building, and that I had used my position to arrange a trap, and that what I was doing was a betrayal of everything a mother and daughter were supposed to be. And her voice was rising in the way that voices rise when the management of a situation has been lost and cannot be recovered, and the glass on 2 sides of the suite returned her voice to the room with the specific clarity of surfaces that do not absorb. And I sat in the chair and I looked at her, and I did not change my expression, and I did not raise my hand, and I waited for the voice to complete its cycle. When it completed, I opened the matte black folder. I said that I wanted to read them the document forensics report summary. And I read it in the register I use for all professional presentations, and I read the conclusion about the digital signature reproduction. And I read the clinic's chief medical officer's statement, and I read the finding that no assessment had taken place, and I read the fraud determination rating, which was the highest rating the forensic unit assigned, and I read all of it without inflection and without the performance of significance, because the significance was already in the content and did not require me to carry it. I closed the summary section. I looked at Amara. I said that the unit's regulations required all falsified medical incapacity filings submitted in support of trustee substitution applications to be reported automatically to the court's fraud division, and that the report had been transmitted on Monday morning at 9:22. And that the fraud division's involvement meant that the matter was now a criminal proceeding and not a civil one, and that criminal proceedings involving fraudulent court filings carried consequences that included prosecution and professional disqualification, and that neither of those outcomes was within my authority to prevent, because the transmission had been automated and the automation had executed according to the protocol, and the protocol did not ask me what I preferred. Amara said my name. It was the first word she had said since entering the room. I looked at her. I thought about a hospital bed on the 5th day of a 10-day recovery, and a mother who had sat beside that bed on the 3rd day and held a hand and said to rest, and had filed a court application 2 days later. And I thought about a key given in good faith 6 years ago, and used to place a document on a kitchen counter. And I thought about a Sunday evening prospectus for an offshore investment structure, and a fund that had been frozen since Friday afternoon, and I thought about what it means to be the person whose name appears on a compliance unit's intake form as both the identifying officer and the protected party. And I thought that the room understood all of these things without me saying any of them. Because the folder was open on the desk, and the folder said what needed to be said, and said it in the language that this building was built to speak. I said that formal representation should go through the case communication process. I said that my assistant would show them out. I looked at the glass. The city was visible through the east wall, and the morning was doing what mornings do, which is continuing. And the continuing did not require anything from me. And neither did the 2 people standing in front of my desk, who had arrived believing that their presence would be sufficient to alter what they found, and had discovered that the thing they found had been built specifically to remain unaltered by the kind of pressure they had brought with them. My mother put her hand on the desk. I looked at the hand. I looked at the folder. I did not move. The fraud transmission document was open on my screen before my assistant had finished showing them out, and I want to tell you about the document because I think the final act of a compliance case matters as much as every step that preceded it, and the document is a single authorization form that requires the head of unit's digital signature to transmit the complete fraud file, including the document forensics report and the forensic determination and the clinic's chief medical officer statement, and the trustee credential rejection logs, and the asset protection measure records, and the blacklist flag documentation to the criminal fraud division's intake system. And the transmission is permanent from the point of authorization, and the permanence is not a caution, and is a description of what the button does. And I had read the document on Monday evening, and I was satisfied that every field was accurate and every attachment was complete, and every finding was supported by evidence that had been generated by systems that do not have preferences about their outputs. I clicked the authorization button at 9:54 on Tuesday morning. The transmission confirmed at 9:55. I noted the confirmation timestamp in my notebook, and I closed the document, and I opened my queue. I heard the lift. I did not look up. I know what happened in the minutes between the executive suite and the building's entrance from the reception camera feed, which I checked once that afternoon, and from my assistant, who mentioned it briefly when she returned. And what I know is that the security team accompanied my mother and Amara from the lift to the public reception suite, and that the lawyers who had been present the previous day were not present on Tuesday, because Tuesday's meeting had not been a legal proceeding and had been a compliance briefing, and lawyers are not entitled to attend compliance briefings under the directorate's engagement framework. And my mother walked through the reception suite with the quality of a person who has understood something in a room upstairs and is now carrying the understanding through a public space, and does not know how to carry it without it being visible. And Amara's quality was different from my mother's quality in the way that it had been different upstairs, which was that where my mother was carrying something. Amara was not carrying anything and was simply moving. And the moving had the specific quality of a person whose forward momentum has been removed and who is operating on the residual motion of a direction. They can no longer maintain. The Criminal Fraud Division acknowledged receipt of the transmission at 11:03 on Tuesday morning. I know this because the workflow dashboard showed the acknowledgement as a case status update, and the update moved the category one urgent case from compliance review to criminal investigation. And the criminal investigation classification meant that the case file was no longer accessible to anyone in my unit, including me, and was now entirely within the Criminal Fraud Division's jurisdiction. And I noted the reclassification, and I noted that my unit's involvement in the case had concluded at 9:55 when I clicked the authorization button, and that everything that followed was the Criminal Fraud Division's work and not mine. The family court issued its order, revoking the emergency trustee substitution in the 6th week after the Tuesday meeting. The order was generated automatically when the Criminal Fraud Division's preliminary findings reached the threshold required to trigger the court's own administrative response, and the administrative response included the revocation of the substitution order and a financial penalty assessed against the individuals who had filed the fraudulent application. And the penalty was calculated according to the court's standard framework for document forgery in proceedings affecting protected beneficiaries. And the framework applies a multiplier to the base penalty when the protected beneficiaries are minors and my children are minors, and the multiplied penalty was the figure that appeared in the court's order. And I read the order when it was published on the court's public record, and I noted the penalty figure, and I noted that the Children's Education Fund had been transferred by court direction to a secure, independent public trust, administered by the Directorate's own Trust Management Division, and that the transfer meant that no individual trustee could be appointed over the fund without the Trust Management Division's approval. And the Trust Management Division's approval process takes 12 weeks and requires a full background clearance. And Amara's background clearance would not pass the first screening. The intermediaries began arriving in the 4th week. They came in the form of phone calls to my office switchboard and emails to the unit's general inbox and one handwritten letter delivered by post. And the phone calls were handled by my assistant, according to the instruction I had given her on Tuesday afternoon, which was that all personal inquiries from individuals not on my professional contact list should be directed to the standard inquiry portal, and that response times through the portal were 30 working days, and that she should provide the portal address and end the call. And the emails received an automated response with the same information, and the handwritten letter received no response because handwritten letters are not a channel. The Directorate's engagement framework recognizes for case-related communications, and the portal remained open, and the 30 working days continued to run, and the intermediaries stopped making contact. In the 8th week, I removed my mother's key from my household records in the 2nd week. I changed the locks in the 3rd week. I updated the emergency contact fields in my children's school records and medical records, and the updated fields contain my husband's name and my professional contact details and nothing else. And I did not notify my mother of the updates, and I did not notify Amara. And the updates were made through the relevant administrative processes, and the processes do not require the notification of individuals who have been removed from contact records. It is a rainy evening. I am standing on the balcony of the executive suite on the 4th floor, facing east, and the city below is doing what cities do in the rain, which is continuing. And the rain moves through the continuing without altering it. And I am holding my phone, and the screen is clean, and there are no missed calls, and there are no messages waiting, and the inquiry portal has a 30 working day response window, and the window has not closed, and I am not going to open the portal tonight. I think about a hospital bed on the 5th day of a 10-day recovery. I think about a handheld, and the word rest, spoken by a woman who had already decided what the 5th day was going to be used for. I think about a kitchen counter and a certified copy and a coat still on and a bag still on my shoulder. I think about a category. One urgent intake form submitted at 8:51 on a Friday morning, and a system that received it at 8:52 and did not stop working until the work was done. The glass house took 34 years to build. It took one intake form to begin the dismantling, and the dismantling took the time it took, and it is done, and the pipeline is clear, and my children's fund is in a secure, independent public trust, and my mother does not have a key to my house, and Amara's profile is on the restricted practitioner database, and the criminal fraud division has a file that is not going anywhere. And I am standing on a balcony in the rain with a clean phone, and tomorrow morning I will arrive at my workstation at 8:35, and I will authenticate, and I will open my queue, and I will process what is in it with the full quality of attention that the work deserves. And the work will be enough. It has always